Welcome to EMBARGOED, intelligent talk about sanctions, export controls, and all things international trade. I'm your host, Tim O'Toole, and with me is a longtime friend of the pod, Leah Mushi. Welcome back to the pod, Leah.
Thanks, Tim.
So today we're going to pick up on a conversation that we had a couple of years ago. I think we talked about Tornado Cash in the context of the Tornado Cash listing. Tornado Cash is a mixing service, depending upon who you listen to and how you describe it, but it works in the cryptocurrency industry. And I think that case and the discussion today is going to lead to a discussion about kind of how technology and the law fit together. And that's good because you and I do a lot of work on cases involving technology and the law, including in the server sector, including in the financial services sector. And so I think this will be an interesting discussion.
Looking forward to it. I agree.
Great. Well, let's get started. Why don't we talk a little bit first about some of the issues related to kind of history and technology and the law, because basically, the law is designed to police conduct that, our government and our people feel is kind of beyond the pale of a civilized society. And some of those laws relate to how technology is used. And so, for example, as cars were developed and roads became, roads and cars and accidents started to happen, we created laws that dealt with the regulation of traffic. And when the printing press was invented, which is a little bit before my time, my guess is that they were creating laws that dealt with the printing press and books and speech and how the law could regulate speech, if at all. The telegraph, internet, all these things evolve, and the law has to figure out kind of how do we fit sometimes very broad and vague legal rules that were designed for other purposes into our legal structure. And I think what we'll talk about today is a little bit about blockchain and cryptocurrency and technological transactions, and a little bit about privacy, because I think part of what's underlying the discussion about both Tornado Cash and the blockchain and cryptocurrency generally is how legitimate an interest do people conducting financial transactions have in privacy? I mean, is that a legitimate protected interest, or is that something that only criminals would want to protect? And I think that argument goes back at least as far as the Fourth Amendment, right? I mean, the protection against unreasonable searches and seizures, some would say, well, why should you care if you have nothing to hide? What's the big deal about having your property searched and having your property seized? Others might say that privacy is an important right in and of itself and serves other legitimate purposes, like allowing for transactions or for conduct that might not otherwise take place. I mean, that's the whole premise of the attorney-client privilege, right? So basically, there are conversations that people have where they potentially even confess to crimes. They have them with their lawyer, they're protected because we decide that privacy in that set of circumstances is more important than criminal law enforcement. So that's kind of the big picture. And so at that point, why don't I turn it over to you to talk a little bit about what Congress is doing in this area, because technology is advancing and the law needs to keep up.
Sure. And I think that's a really good way to sort of set the table in this space. I mean, what you hear, I think, is a couple of different things from people who are in the industry. You have a lot of asking for clarity from Congress on how to handle some of these new technologies that really are not covered by existing laws. And to be clear, we are not talking in this context about conduct that would otherwise fall neatly within the existing criminal statutes, but that use crypto as the mode to commit it. So, for example, there have been plenty of crypto fraud cases that have been the subject of a lot of scrutiny. Those are, if you read the facts of many of those cases, are a typical fraud case that you've been seeing for decades and decades and decades. The only difference is that crypto is the method or the manner in which the fraud is being committed. I think today we're with the discussion on the Roman storm verdict and more broadly about Tornado Cash. I think it's a little more nuanced, and you're talking about conduct and a technology that really does not fit neatly within some of the statutes, at least in my view. But I think this all leads back to a broader question and, frankly, root problem, which is that Congress for the last decade or so has really been lagging behind and has frankly been largely paralyzed in trying to update the statutory framework around digital assets. We've seen some small steps and some small victories, especially recently. I mean, you see things like the Genius Act coming out, developing some frameworks for stable coins. Folks in the industry and folks in Congress have been pushing other types of legislations or trying to push them through over the years. And I think the one most on point or very close to on point for today's purposes and discussion is the Blockchain Regulatory Certainty Act, which is a bipartisan bill that would codify that digital asset developers and service providers that don't custody funds, that don't custody consumer funds, would not be considered money transmitters. So these are things that folks have been trying to push through with Congress, but where we are right now is they haven't been pushed through. So it creates a lot of uncertainty, and when something does break bad and bad actors and conduct is identified, there is sort of the natural tendency of wanting to hold people accountable. But I think there's a big question of whether the laws on the books right now, especially in the digital asset space, are well situated to do that.
Yeah, that's one of the issues that I found kind of striking with the conviction in the Roman Storm case, which we're going to talk about soon. But basically, you've got a law that is kind of the one law where there was a conviction, where it's a money transmitting business. I mean, it's like wiring people money is such an antiquated kind of technology. People used to wire money back in the day. If you watch like 1940s, 1950s movies, and that's where you'd get wired money. Today, money transmission businesses are so kind of behind the times that a statute that was designed to regulate and potentially criminalize some conduct with respect to a money transmission business, including kind of failing to register as such a business, seems pretty outdated when you're dealing with a business that is designed both for to engage in certain services related to cryptocurrency. It just doesn't seem to fit, but because the law is so antiquated, you've got to kind of put square pegs in round holes. And that is really kind of the problem here that I see, is that you've got this, you've definitely, the backdrop of the Tornado Cash case is that people can use cryptocurrency, and particularly mixing services, in ways that can disguise transactions. Sometimes if you want to buy a piece of property and you don't want to know that you don't want people to be able to figure out from the public record who's buying it. Like, say, Jeff Bezos wants to buy a piece of property in a particular area, but doesn't want everybody to know that Jeff Bezos is going to buy it because it would drive up the price of the property, because he presumably has an unlimited amount that he can pay. You might want to use cryptocurrency or a straw buyer to try and make sure that you don't get ripped off in terms of the price, because they know who the buyer is. And that is kind of one of the things that you can do with these mixing services. But you can also, people who are engaged in bad conduct, in sanctions evasion or in other types of conduct, can use these services as well. And so regulating those services, it strikes me, you would want a law that actually looks at those services and kind of carves out what's good and what's bad. And taking a law that was created to regulate Western Union is going to necessarily lead to lots of unanswered questions with respect to what you can and can't do, and in this case, when you can and don't need to register.
Absolutely. Maybe we can jump in a bit on what the Tornado Cash is, or what the parties argue that it is, and how that informed where the verdict and where things landed in the last couple of weeks with the Roman Storm case.
Yeah. Go ahead. Why don't you jump in and talk a little bit about kind of the backdrop?
Sure. So I think, and you alluded to this, but I think part of the confusion and the interesting aspects of the Roman storm case and the broader tornado cash case is the debates amongst the parties on how to define tornado cash. At its core, tornado cash is essentially a series of smart contracts, which smart contracts are these open source applications where any user in the blockchain can deploy them and then use them to interact with the blockchain.
Which I think, just to jump in on this, a lot of the terms that you're going to define have terrible names when you try and put them up against the legal concepts. I actually think that part of the big problem in the sanctions against Tornado Cash and also kind of the litigation with respect to Tornado Cash is that they call these things smart contracts, but they're not contracts at all. They're just like application services that basically anonymize transactions. But when you call them contracts, it's natural that OFAC would say property. Aha, it's a contract.
Right. Right. And that was a big dispute and ultimately shook out with the Fifth Circuit. But for purposes of understanding Tornado Cash, they are called smart contracts, so folks in the industry will recognize them as such. But for Tornado Cash, the way that the smart contracts worked is essentially these applications would allow users to deposit Ether or other Ethereum-based tokens, and then the user could withdraw Ether from these pools, the smart contract pools, to a new Ethereum address without a connection between the deposit address and the withdrawal address on the blockchain. So it breaks that on-chain link between recipient and destination address. And Tim, you talked already about privacy interests. Of course, something that could obfuscate or provide some cover or privacy could be used by bad actors. I think you would have to be living in a hole not to admit that. But of course, and you see this all over the media and in the defense's arguments, there are legitimate reasons why folks would want to use privacy tools. I think a couple of examples frequently used are people who want to make political or donations to unpopular causes, dissidents in authoritarian countries, trying to make those types of contributions. Of course, people who have a lot of crypto or a lot of virtual assets who want to stay under the radar so they don't become victims of financial crime on the blockchain. So there are a lot of legitimate reasons why one would use a privacy tool. But of course, it could also be used by bad actors. So going back to the Tornado Cash, so it's essentially, as the defense describes it, a set of non-custodial smart contracts. So nobody's taking the funds, but rather the user who's engaging with the smart contracts is telling it what to do in terms of depositing and withdrawing. They're given a secret notice certificate on deposit, and whenever they want to withdraw, they have to use this secret notice. And so what the defense and sort of a crux of a lot of their arguments is there was no custodial taking by the smart contracts of Tornado Cash. Another thing that's interesting and important from just on a purely legal matter is that after a certain period, Roman Storm and his co-founders relinquished any ability to make changes to the smart contracts that served as the basis of Tornado Cash. So I think as of I think the defense said sometime in May of 2020, these smart contracts became immutable, meaning that no one, Mr. Storm or anybody else, could modify or disable them. So that's a bit about the technology underlying Tornado Cash. The only thing I'll add is that DOJ defined Tornado Cash service more broadly and focused also on sort of a user interface that operated alongside the smart contracts that it said was under control of the co-founders. It also talked about other actors in that the defense says are third party or independent actors called relayers. These relayers are independent third parties that can help users withdraw their funds, and basically it's an additional layer of privacy if you're operating on the Ethereum blockchain, and when you do transactions you have to pay gas fees, and if you don't use Relayer in the context of Tornado Cash, you would have had to pre-fund the wallet that you're trying to send the funds to for the gas fee, and if you pre-fund, somebody could have sort of traced back and may see where you're pre-funding from, and that weakens the privacy. So people rely on these relayers to help protect vis-a-vis these gas fees.
So basically, that sort of privacy setup is not that dissimilar from back in the day when people would use cash. People would use cash for transactions, and then they might impose a straw buyer to pay in cash for a transaction. It might be a completely legitimate transaction, and certainly cash is a completely legitimate form of currency that has had lots of good uses in the past, but also, like some of the financial instruments we're talking about here, is also more difficult to trace than kind of a simple wire that passes through multiple banks. And so basically, I mean, what we've got here is kind of a situation where you've got a legitimate interest in privacy. I think we can all agree about that. But also, and even legitimate instances kind of popping out from this case, at least from the way the defense portrayed him. Roman Storm, it was a dissident in Russia who emigrated to the United States based on what happened in Georgia with respect to Russia 15 years ago. I think in one of the briefs, the defense gave an example of, let's say he wanted to make a contribution to Ukraine, to the effort in Ukraine, and didn't want anybody to know about it. This would be a totally legitimate donation and a totally legitimate reason to want to remain anonymous. And so there are lots of instances where these sorts of privacy interests are legitimate, but they also, can be used by people who are engaged in sanctions evasion, are engaged in hacking, and the prosecution does a good job of citing those sorts of instances, and those turn out to be, as we'll talk about a little bit, the premise for the complaint in this case, or for the indictment in this case that went to trial. But before we get to that, why don't we talk a little bit about the troubles that Tornado Cash got in with OFAC, because I think that they first came to the attention of U.S. regulators through OFAC. And OFAC sees these smart contracts and says, well, you are engaging in smart contracts with your users, and therefore those contracts are property, and those contracts can be blocked. And since those contracts are the ones providing the anonymity, the blocking and really was the service that Tornado Cash was selling, we're blocking all the smart contracts because we can block property. IEPA allows us to block property. We have a really broad definition of property, and though it doesn't include smart contracts per se, it includes contracts, and this seems like property. And that blocking was challenged by Tornado Cash. Actually, Tornado Cash customers challenged it and said, hey, come on, you've blocked a service that is not property, and in fact, injured us in the process. And ultimately, after losing in the district court, the Fifth Circuit, with the benefit of Loper Bright, said, well, we don't care how OFAC defines property, because that's a term in IEPA. That's a law, and the Congress passed it, so we're the court. And OFAC can tell us what it thinks that means, and that we'll listen to them, but we get to decide, and we're not going to give them any deference in deciding, and determine that smart contracts weren't property and overturned the listing. And then later, OFAC went back, I think, and listed again, but ultimately delisted in 2025 because of various novel legal issues that applied to the listing itself, because Tornado Cash continued to challenge the listing, and I think in the face of pretty strong challenge, OFAC backed down and just walked away from the sanction side. But then, kind of, instead of trying to sanction Tornado Cash, they indicted Tornado Cash, or at least indicted the individuals who founded Tornado Cash. And that's kind of where we come into the most modern part of the story.
Sure. And so it was, I believe, around August of 2023 when Roman Storm and his co-founders were indicted. And Mr. Storm, who's a naturalized U.S. citizen who's based, I think, in the Seattle area, was charged with 3 criminal violations. He was charged with conspiracy to commit money laundering, conspiracy to violate the IEPA, so violate U.S. sanctions laws, and then conspiracy to operate an unlicensed money transmitting business. It has been a long and drawn out process, but just about a week and a half or 2 weeks ago, the trial concluded, and to sort of spoiler alert, it was an interesting result from the jury. The jury came out and convicted Mr. Storm on the conspiracy to operate an unlicensed money transmitting business, but was deadlocked on the money laundering and sanctions conspiracy charges. So I think right now we'll walk through a little bit about those different charges and sort of what served as the basis of the arguments on both sides. Um, I don't know, Tim, before I jump into that, is there any initial reactions that you had on hearing about the verdict?
Yeah, I mean, I will say this, and again, if you were actually involved in the trial, you're welcome to come correct me. And if even if you weren't, if you know more about the trial, please feel free to correct me. But just watching from the outside and not all that closely, I mean, my sense was that the defense did a nice job of drawing a line between kind of what Mr. Storm did with what customers of Tornado Cash did, and I think at least the way that I would explain the deadlock on the 2 more serious charges from the outside is that essentially those were charges that were based on the conduct of the customers, and essentially alleging that Mr. Storm conspired with them to commit that bad conduct, which seems, at least from the outside, like a bit of a stretch. I think that the other charge was at least aimed at Tornado Cash. Like, you were a money transmitting business, or at least you conspired, or you didn't get a license as a money transmitting business, and so you did that, so we can hold you accountable. And I think that at least to me, in a very simple way, explains kind of maybe how the jury saw it through its own eyes. Is one set of charges, it was what he did. The other set of charges was trying to hold him responsible for what somebody else did, and this just didn't seem like enough of a link to box number 2.
I think that's exactly right, or I share your views. And I think as it relates to the money laundering and the sanctions charges, um, it to me seems very challenging to establish the required intent, and all that is needed to establish a conspiracy. Um, if you were talking about developing code that was made immutable prior to when some of the conduct was alleged to have occurred. Now, I know that the prosecution takes a different view of some of the facts, but for me, reading the motion to dismiss and some of the other things available in the public sphere, I mean, I thought that was pretty compelling, and especially on the money laundering charge, this idea that that the 1956 cannot be read or extended to create a negligence standard for money laundering, I thought was frankly a pretty compelling argument.
Yeah, I mean, honestly, the criminal to me, the criminal case here, if there ever was one, would have had to have been, and maybe maybe in the prosecution's mind it was, but if you run a service and you know that you have a bunch of users of that service that are using it to hide the proceeds of crime, it would be one thing to say to confront someone, say, you're doing this, you've got to at least try to stop it, and then they take certain actions either not to try and stop it, or even to kind of look the other way, or to repeal, essentially, or never put in compliance measures that would stop this, right? Or at least easily available compliance measures. You could argue intent from that. And I think that building a record of, like, we told them that this was happening and we told them how to stop it and they didn't, maybe that was their case, but if it was, I really haven't seen it portrayed that way. And to me, like, that's how you would set up a case like this: is that if you're going to bring a case based on somebody else's conduct, you got to show a lot of knowledge and then refusal to do anything to prevent that conduct.
Right. And I mean, that's the type of case that is typically brought, with a more traditional financial institution under the Being Secrecy Act. And, uh, it's pretty clear, like from the regs, if you look at the BSA, like it allows for that type of a case. I think with respect to just going back to where we started, it's trickier when you're talking about a mutable code. If you accept the defense's position, then that's what we're talking about here is simply smart contracts interacting with the blockchain and not all of the other stuff like the user interface and the relayer network and all of these other things that are layered on top of it. To me, that makes it a much more interesting question about under 18 USC 1960, the unlicensed money transmitting charge. And it really calls into question, I think, makes that statute very vulnerable to attacks on, constitutional vagueness and due process arguments regarding like who could truly be covered by that. For those, we probably should have laid this out a little earlier, but for those who aren't familiar, so the charge that Mr. Storm was convicted on is 18 USC 1960. And prior to this case, it was broadly thought amongst folks in the industry that non-custodial platforms would not trigger FinCEN registration and compliance obligations under the Being Secrecy Act. And I want to try not to conflate too much 18 USC 1960 and the Being Secrecy Act, because that's also a point of contention amongst the parties, which is, are the definitions the same? Are they overlapping? But basically, the initial indictment against Mr. Storm charged 1960 conspiracy on two alternative theories. The first was that he was operating the money transmitting business without having registered with FinCEN. And then the second was that he was operating a money transmitting business that involved the transportation or transmission of funds that were known to him to have been derived from a criminal offense. Interestingly, the government later dropped the prong or the charge related to operating the business without a FinCEN registration after the DOJ issued its memo in April of this year, and that was called the Ending Regulation by Prosecution. And the upshot of that memo is that it's instructing DOJ prosecutors to cease any litigation or enforcement that's essentially would have the impact of superimposing regulatory frameworks on digital assets, consistent with the current administration's, stated goals of trying to be looked upon as sort of crypto friendly. But all of that is to say, where that leads us is that the government then is alleging that Tornado Cash, through its user interface, these smart contracts, this series of relayers, is enabling this transfer of value between parties. It's just a little bit messier, I think, than if you're talking about, like you said, Tim, or it's much messier than if you're talking about like your Western Union or your typical money transmitter.
Yeah, I mean, it seems like, as best I could tell, any company that has anything to do with financial transactions could fall within that definition, because at least what I saw was the defense trying to say, well, at least you have to have at some point in the process had custody of the funds. And I don't think it was really disputed that that Tornado Cash never had custody of the funds, but I didn't see anywhere in any of the laws that were cited that the term custody was required. So the government essentially said that just isn't required to be an unlicensed money transmitting business. You just have to be involved in the transmission of funds. But any involvement in the transmission of funds, triggers both 1960 and also a registration requirement, which doesn't leave a whole lot in terms of money transmitting business, because it certainly doesn't fit the paradigm, I think, that was set out for regulating these businesses. And it creates kind of this very significant confusion as to who would constitute a money transmission business and who wouldn't.
Well, and the thing, putting aside applying the facts to the instant case, where I think it leaves folks more broadly, and we work with MSBs all the time who are, seeking to comply with the compliance obligations under the Bank Secrecy Act. But it would seem in this case that the DOJ is essentially saying that the definition of money transmitting business and the definition of money transmitter, the 1960s definition of money transmitting business is not the same as, or should be treated slightly differently than the definition of money transmitter under FinCEN's regulations. And I'll be honest, like, we deal with these things all the time, and it's even hard to parse after you spend a lot of time reading through it. So if you're just in the industry and trying to figure out whether or not you could be subject to either civil or criminal liability, it's I think a really challenging place to put people in the industry in.
Yeah, so this is another pitch for keeping the laws up to date with the technology and the businesses. I mean, if you tell a business you are clearly within the scope, here's a concrete definition, that includes, if you want to get very specific, it includes what the government would view as mixing services, right? Mixing services count as a money transmitting business. If they say that, maybe you can argue as to why or whether or not that's a good definition, but it's a definition that puts people on notice that they have a registration requirement and that they are going to be subject to 1960. If you have basically no definition, or a definition that is so unclear that there's a difference between basically the same terms used by FinCEN and the same terms used in the criminal context, and nobody can figure out what it means, you really do lead to cases like this one, where, I mean, a jury decided that this was a money transmitting business, even though it apparently never had custody of the funds. But that is not a very satisfying answer, because they certainly don't seem to fit what the natural reading of those terms would imply.
I agree. Should we talk a little bit about the sanctions charge?
Yeah, why don't we talk a little bit about the sanctions charge? So, I mean, the sanctions charge was essentially that there was a conspiracy among the Roman Storm and essentially the users of Tornado Cash, who had engaged in sanctions violations and then sent funds through that mixing service using the smart contracts that you talked about earlier. That was essentially a conspiracy to evade sanctions. That they had kind of made the money from the sanctions. He and Tornado Cash had provided the tools to allow them to clean that money and take it out the other end, so that nobody would know that it was the product of sanctions evasion. And so the two, working together, had essentially conspired to evade U.S. sanctions. The problem with that, I think quite obviously, is the people from Tornado Cash never had any contact, implicit or implicit, with any of these customers. And so to prove a conspiracy, you need an agreement. And so it's really hard to say. I mean, it can be implicit, but if I create a service in, 2020, and you go do something with that service in 2024 completely, without my assistance, knowledge, or anything, 4 years after I've kind of walked away and just thrown this code into the air, how can I be conspiring with you to evade sanctions? I guess the argument is that implicitly in 2020, I was agreeing with anybody in the world who wanted to evade sanctions that we could work together to do that if you would just use this code. And so presumably he's on the hook forever, or at least as long as Tornado Cash exists, for sanctions evasion, because it's out there, and anybody who wants to use it to evade sanctions is going to be on the hook. I mean, it seems almost like, you would hold the U.S. Treasury responsible for somebody who uses cash to, launder money, because they invented cash, and cash can be used to launder money, and therefore the U.S. Treasury is in an implicit agreement with all the sanctions evaders in the world to evade sanctions, because they print money.
Yeah. I think my sense is what the government argued, or where they would draw the line, is that they believed that the co-founders exercised some level of control, at least as it relates to accessing the platform, because they at some point they were controlling this user interface. Now the defense takes a lot of energy to explain that you could also direct access, the pools, the smart contract pools, without the UI, or you could use other UIs.
And this is where, like, my not complete knowledge of the facts kind of falls down. But again, this is where I would think that the government's case, to the extent that it's a winning case, would need to be made based on that sort of argument, that you engaged in, commercial relationships with the people who did this, and essentially had, at the very least, the ability to know that where this money was coming from. And again, if you built a record, and I'm not sure that it was here, but if you built a record that essentially the government had kept going back to Tornado Cash and to Mr. Storm and said, hey, you've got XYZ sanctions evaders that are putting money through your system. You need to start asking them, about what they're doing. You need to start kind of screening them. You need to start doing, the sort of due diligence that BIS is having companies do in connection with the sale of chips, for example, or certain chips. And so, if after that nothing was done, maybe you can infer that these sorts of agreements were tacit agreements to allow people to evade sanctions, because they were so clearly on notice that that's what their customers were doing. I don't know if they had that record, because I think there were, that it was more of a legal argument that yes, this could be a contract because you have a contract to allow them to use the system, but the contract has to be to conspire to break the law. And I haven't seen much of that, but I'm sure that if we had the prosecutors on here, who are great people, they could tell us all about where that evidence was. But that strikes me as the sort of evidence that you would want in a case like this if you got to prove a conspiracy.
Yeah, and but I think the major uphill battle with that argument, and I think the prosecution tried to really hook onto the UI and other features of the add-ons, I'll call them, of Tornado Cash. But at its core, I think what the defense would continue to say is this was an autonomous set of smart contracts that were working. And after the control was relinquished back in May of 2020, like Roman Storm, anybody else had no control over what happened with them, which is, I think, something not contemplated by criminal laws that are on the books right now.
I agree. I also, one of the things that I haven't seen, and maybe you know the answer to this, I'm not sure how they got paid. So how did Tornado Cash make money, and how would it make money? Like, who would be paying them?
Yeah, so that's a really good point. So what ended up happening is they developed these torn tokens, which were essentially like the governance tokens. And you can acquire torn tokens in a bunch of different ways. And it's at least suggested in the record that at the time they were issued, that the co-founders, including Mr. Storm, obtained a bunch of torn tokens. But you can think of these as like the voting chips of Tornado Cash. And so the decentralized governance body of Tornado Cash would basically use these torn tokens to help decide how the smart contracts would work. So adding features, changing settings, but it was all done by this DAO. So this governance organization, and it was done based on these voting chips. I think what the prosecution tried to argue is that Mr. Storm and others sought to make money based on the value of those torn tokens going up or rising. And they could, if Tornado Cash, as it became more and more popular and more people wanted to get involved and wanted to get access to controlling the project, the value of those torn tokens would rise. And then Mr. Storm and others presumably could go and sell those tokens and make money from them. I think there was also some arguments throughout, and I admit I don't know all of the details, but around the relayer payment. So these relayers that would come in and essentially cover, help with the withdrawals, get these fees for these relayer fees from the users. And I think there was some question about whether Mr. Storm or others were making fees as relayers. I don't frankly know where the facts landed on that one, but I think that's another way. But the torn tokens was a primary part of this.
So it seems like even the design of the payment system is almost not to interact with the users. Like that seems to be almost the point of that.
Absolutely.
And
Absolutely.
on the one hand, you can frame that as they didn't, willful blindness, right? That is, they didn't know what these people were doing because they set up a system where they didn't know because they didn't want to know because if they had known what they were doing, then they would have been involved in um, potential money laundering with respect to various crimes and potential sanctions evasion to the extent that what was going on was people were evading sanctions. The problem with that, I mean, and that's that certainly has a certain ring to it, but the problem as I see it is the whole service that they're really selling is privacy. And so the more interface that you demand with the users and the more due diligence that you do, the less valuable that service is going to be. And I'm not saying that in a way to say that that's like means that you can't do due diligence or that the government shouldn't try and make that happen. But I do think it's a challenge because essentially they're selling a service that says we're going to give you anonymity or privacy because privacy is valuable. And that isn't that controversial a principle, but how you get there is hard because things that look like privacy on the one hand also look like concealment on the other hand, and so to the kind of the prosecutors look at the tools that are designed to prevent direct interaction with the user as you're just trying to conceal what's going on.
Right.
Whereas those same tools are also designed to legitimately protect privacy at the same time. And so how do you decide, whether it's bad concealment or good legitimate privacy protection?
Right. And I think even more macro too, it gets us to a point where if you are a developer and you're interested in developing, um, projects in the space that where at some point you would relinquish control and not have direct oversight or have the ability to stop bad actors from using your project, at what point does your liability start and at what point does your exposure, your criminal or civil exposure end? I mean, we have a hard enough time, um, just going back to the Bank Secrecy Act. I mean, with some of the new companies out there that are semi involved in financial transactions that aren't, your traditional banks or financial institutions, understanding if they fall neatly within the definition of a money services business or whether they can claim exemptions. Like with some of these new companies that are super novel, that can be an interesting analysis. But I think this analysis on the criminal exposure is even more complicated, and frankly, the stakes are even higher for folks who are not even trying to get in the business, in the financial services business, but are, well, I should, they're on the blockchain, and they're developing a code that could potentially be used several years down the line. Like, at what point should they be on notice that that they could face criminal exposure? And I'm not sure the laws answer that question right now.
Yeah, I mean, we were talking before the pod about a case filed in Texas that is essentially a bunch of code writers who are doing exactly what you're talking about. It's this Llewellyn versus Bondi case where the code writers have sued saying, we're just writing code. It's for the blockchain. And code is protected by the First Amendment. And we're worried that, we saw this Tornado Cash case, this Roman Storm case, and now we're worried that just for writing code, we could be engaging in conduct that contravenes the criminal laws. We'd like a declaratory judgment that this conduct is protected by the First Amendment, and or if it's not, and that any criminal law that would be used to criminalize this conduct is void for vagueness and can't be used. I mean, it's kind of an interesting conundrum because that issue, at least as I saw it, was raised in Tornado Cash, the First Amendment issue. I didn't find it all that compelling when you're essentially running a business. The fact that you're writing code as part of that business and then using code to do various things, you know, I it's one thing to say all information, including code, is protected, but you would have a hard time putting the plans to build a nuclear bomb online, even though that's just plans, right? Those are protected First Amendment plans, I suppose, but if they have the ability to do various things that are problematic, and then you're commercializing them, and so it's essentially commercial speech. I think the First Amendment argument is weaker, particularly if you're running a business that doesn't just involve code. But the civil lawsuit kind of brings that issue to its kind of cleanest point by saying we're just writing code, and we're really worried now, and not without reason, because somebody's been charged with this, and we're even potentially worried that because we're writing code that pertains to the blockchain and involves financial transactions, that we could be seen to be a money transmittal business
Yeah.
and would need to register.
And I think that just writing code piece was essentially the opening statements of the defense in the Roman Storm case. And I think they would take issue with the running the business part. And I think that's really where the government tried to define Tornado Cash and its offerings as a broader bucket that was more in the control of Mr. Storm and others.
Yeah, I mean, this is why I came around to the how's the business getting paid point. I mean, because okay, you're just writing code, but then somehow you set up a system where people who use that code will pay you. So you're not just writing code, you've got a business to sell the code. And so to publicize and sell the code is not the same thing as just writing code,
Yeah.
and potentially carries other implications in terms of
Right.
the ability of the government to regulate.
I think we put our finger right on where the legislation needs to come in and help clean this up.
Um, all right. So why don't we talk a little bit about the need for that legislation? I mean, it does seem like the rules here that the statutes that were being charged didn't really fit the type of conduct that was involved in this case. You have someone who is alleged to be essentially using a technological tool to allow either concealment or legitimate privacy for financial transactions, some of which violated the sanctions laws and some of which violated other criminal laws. It would be nice to have a law that said, okay, if you're operating a business that could potentially be used in this way, if you do X, Y, and Z, then you can violate the criminal laws. And if you do A, B, and C, you won't violate the criminal laws, or at least something along those lines where the law is directed towards at least that line of business, so that if I'm running a business in the cryptocurrency sphere, I can tell where the line is, so I can make an actual decision whether to cross it. Whereas here, I've read quite a bit in this case over the years, and I still would have no idea how to advise someone where the line is.
Yeah, and I think to that point, 18 USC 1960 is begging for a facelift. I mean, it's really challenging. There was a lot of really good amicus briefs filed in this case, and you have a lot of really smart people opining on the 18 USC 1960, whether or not it overlaps and how it overlaps with the BSA and the definitions and guidance put out by FinCEN. And I'm not sure that a coder or anybody else who's not a legal scholar would have any sense of where they should start and stop if they're looking to abide by those rules. And so I think that would be a really solid place to start.
Yeah, and I think one of the things, I agree, 1960 is definitely in need of a facelift. And I think on the bigger point of kind of why don't our laws match kind of our technology? It would be really nice to have people who understand the technology in the room when these laws are getting written. And I assume that they are to some extent, although for most of them they aren't, because the laws were written long before the technology ever existed. And so, I mean, and I'm not just seeing it um, Tornado Cash. I mean, I see it in the broader picture, particularly in these export controls that relate to supercomputers and super chips and high level technologies where it's really hard for a layperson to understand the law because it seems to be written by people who are technical experts in the law and maybe understand the technology, but maybe don't quite understand how to draw a clear line between what you can and can't do and the importance of clear rules. Because if you have clear rules, they're likely to affect behavior um, much more much more productively than a vague rule. Because these vague rules where nobody knows where the line is, you don't know how to conform your behavior even if you want to. And so what you have is this system where everybody feels like they're at risk, and you either deter technological innovation because nobody wants to go into that field because it's so risky, or you just have a bunch of people who are like, I don't know what the rules are, I'm just going to run my business and I hope lightning doesn't strike because I don't even know how I would comply even if I wanted to.
Yep. I think that sums it up pretty well.
Well, thanks for coming back to talk about Tornado Cash and mixers and smart contracts. Let's do this another time.
Yeah, it will be interesting to see where things land, whether the government decides to retry Mr. Storm on the sanctions and the money laundering conspiracy charges. And it seems like the defense is continuing and will continue to put up a fight on that unlicensed money transmitting charge. So maybe we can look forward to a little clarity there.
Yeah, it looks like the defense is going to take a little time to try and file its post-trial motion to dismiss the charge or motion for judgment notwithstanding the verdict, because I think they got through the end of October just to file the post-trial motion, and I think the court is going to hear the case in December. So we'll know soon, but not that soon. This is a complicated issue. It'll take a while. All right.
Awesome. Well, thanks for your time.
Yeah, thanks for joining Embargoed. Stay sanctions free, everybody.
Produced by Heartcast Media.